this is going to be our look into Damone Blalock's trial. So here we go. Part 1, Statement of Jurisdiction. The Supreme Court of Georgia, rather than the Court of Appeals of Georgia, has jurisdiction of this case on appeal in that constitutional questions are at issue and the offense of conviction is murder. So 2 reasons that the Supreme Court of Georgia should hear this. And they've agreed to hear it. We're getting the oral arguments on the 5th. Statement of the case. On or about May 24th, 2019, appellant was indicted by the grand jury of Fulton County on count 1, participation in criminal street gang activity, count 2, malice murder, counts 3 through 5, felony murder, counts 6 through 8, aggravated assault with a deadly weapon, count 9, criminal damage to property in the first degree, and count 10, possession of a firearm during the commission of a felony. Pursuant to a jury trial in the Superior Court of Fulton County, on or about September 30th, 2021, appellant was found guilty of all indicted counts. On or about October 1st, 2021, appellant was sentenced to serve life in prison on count 2, malice murders, counts 3 and 4, felony murder, were vacated as a matter of law. Count 6, aggravated assault with a deadly weapon, merged with count 2 for sentencing purposes. 10 years to serve on count 7, aggravated assault with a deadly weapon, to run consecutive to count 2. 10 years to serve on count 8, aggravated assault with a deadly weapon, to run consecutive with count 7. 10 years to serve on count 9, criminal damage to property in the first degree, to run concurrent to count 7. And 5 years to serve on count 10, possession of a firearm during the commission of a felony, to run consecutive to count 8. So, a lot going on there. Thus, appellant's total sentence is life plus 25 years to serve in prison. A timely motion for a new trial was filed on October 6, 2021. An amended motion for a new trial was filed on February 3, 2023. A second amended motion for a new trial was filed on September 18, 2023. A third amended motion for a new trial was filed on February 12, 2024. The motion for a new trial was denied on May 20, 2024. It is from the sentences, convictions, and denial of appellant's motion for a new trial that this appeal is taken pursuant to the notice of appeal filed on May 16, 2024, an amended notice of appeal timely filed in the Superior Court of Fulton County on May 22, 2024, and docketed with this honorable court on July 16, 2024. So, statement of the facts. Trial commenced after jury selection, and the parties then presented opening statements. The state's first witness was Miss Sharon Latners, through whom 911 calls, a familiar face, guys, and a CAD incident report was entered into evidence. City of Atlanta police officer Hodea Mitchell responded to an emergency dispatch and saw a blue Dodge Charger off the roadway and found a male who appeared to have suffered a gunshot inside of said vehicle. And these, when you see this, guys, these are transcripts. So when you see a citation here that says T something, they're referencing a transcript from the trial. Law enforcement officers arrived at the scene, canvassed the area, located evidence, and processed the scene. An expert in firearms analysis opined that shell casings from 2 different guns were discovered at the scene, but was unable to determine the type of firearm that fired the same. Mr. Bernard Mitchell, that's BJ, that is the same person that, Leah Bossie motioned for a mistrial because the state was going to call them. They never called them. Leah was unsure. She's like, hey, I thought you said you still plan to call them. And Adam Abadi was like, no. And Whitaker was like, well, what happened? And Abadi was like, I remember everything. I'm not lying. And Leah was like, I'm not saying my memory is perfect, but I didn't know you weren't planning to call him anymore. Now there's an issue. So, and then Whitaker apologized a couple hours later because she had seen that it did seem like Leah was correct. So that is Bernard Mitchell. That is that witness that the sheriffs had transported twice, but the state never called to the stand. So Mr. Bernard Mitchell testifying that he and Mr. Jamari Holmes, hereinafter the deceased, so Holmes is the deceased, stole a blue Dodge Charger on February 23rd, 2019, and drove the same, along with Mr. Rodney Red Uten, to 50 Mount Zion Road to chill with some females, named Miss Tahira Brazy Hartfield and Miss Mariah Smith. Now, You guys may have seen, I know Chadigi was on it, mentions of, well, they stole this blue Dodge Charger. So some may be familiar because it's been talked about outside. But in the trial that's still continuing, the YSL trial, you don't really hear this. It's kept out because it's bad character evidence for the victim, right? So what the jury's hearing in this trial that this appeal is for is a little different than what in YSL that jury would have been able to hear. So back to Mitchell's testimony here. The deceased had organized the meeting with Miss Hartfield that night, and the plan was to meet these two ladies and buy marijuana. Upon arrival at the destination, Miss Hartfield went to obtain marijuana. Remember, Hartfield, Brazy. Hartfield is Tahira, Brazy. Returned to the car minutes later and told Miss Smith that someone needed to see her. So Miss Smith exited the car, and a few moments thereafter, gunshots were fired into the car, and Mr. Mitchell attempted to drive the car to safety. Mr. Mitchell testified that he possessed an unloaded weapon at the time of the shooting, but did not fire a weapon and did not see anyone in his car shooting a firearm. The morning after the shooting, Mr. Mitchell turned himself into custody, answered questions by law enforcement, but was not arrested. Mr. Mitchell was a reluctant witness and at the time of trial was housed in the Fulton County Jail, but was not threatened in any manner. Mr. Mitchell handwrote a note which was entered into evidence, which explained that Co-Indictee Ryan is innocent. Rodalius Ryan. Mr. Mitchell. In this situation, if you ask me, the op. Bernard Mitchell. In the car that Rodalius Ryan and Damone Blalock were allegedly shooting at from the bushes. Mr. Mitchell handwrote a note which was entered into evidence which explained that Co-Indictee Ryan is innocent. Mr. Mitchell testified that he did not see the perpetrators, had no idea who they could be, and that he believes the accused are innocent. Mr. Mitchell stated that they threw his gun into the woods near the area. This is the witness that the state did not want to call in this trial. The trial court was informed that Ms. Hartfield intended to invoke her Fifth Amendment privilege rather than answer questions. This is brazy. The prosecutors argued that Ms. Hartfield could not invoke her Fifth Amendment privileges because she was not accused of any crime relating to this incident and was not going to make any incriminating statements. Oh, because the prosecution always knows the truth. Let's read this back. The trial court was informed that Ms. Hartfield intended to invoke her Fifth Amendment privilege rather than answer questions. The prosecutor argued that Ms. Hartfield could not invoke her Fifth Amendment privilege because she was not accused of any crime relating to this incident. Prosecution argues she was not going to make any incriminating statements. Because the prosecution knows what could actually be incriminating or not, apparently. They know the truth. They know what's a bold-faced whopper versus what's not, always. They just know. Outside of the presence of the jury, the trial court explained to Ms. Hartfield and her counsel, Attorney Callier, that the trial court expected Ms. Hartfield to answer any non-incriminating questions, and if she does not, then the only procedural option would be to hold her in contempt, criminal contempt, for refusal to testify. We've got a footnote. Ms. Hartfield was in jail at the time of appellant's trial. Mr. Uten, who was in the car with Mr. Mitchell and the deceased at the time of the shooting, testified that he recalled bullets fired into the car and driving for safety, but did not remember much else from that night. Mr. Uten was not a cooperative witness. There's a typo there, and upon cross-examination, he was fairly unresponsive and gave short answers. Mr. Henry Bell, whose home Mr. Mitchell and Mr. Uten appeared at after this incident, testified that when Mr. Mitchell and Mr. Uten arrived at his house, they were sweaty and after collecting themselves, told Mr. Bell what happened. Mr. Bell stated that they did not call the police because they were trying to figure out what was going on. He stated that 2 videos which were taken of a phone call with Miss Hartfield from the night at issue, did not capture the entire phone call. Miss Tahira Brazy Hartfield was questioned by the state, but invoked her Fifth Amendment privilege to not respond to any questions that could potentially incriminate her on direct and cross-examination. On cross-examination and redirect, she testified that she was threatened about this case by Miss Mariah Smith and a handful of others. Finally, when questions were posed by the jury, Miss Hartfield refused to answer. Whether she knew the deceased was shot in the car on February 23, 2019, and 2, why Miss Mariah Smith stated that Miss Hartfield assisted in the planning of the deceased's death. Now, it's interesting here that the jury asked questions. We haven't seen that in this trial. Is that something that's allowed in Georgia trials? The jury can ask questions? That's very interesting. That's very interesting. Maybe it's a... How old was Blalock? Maybe there's certain circumstances, or maybe it's the judge that allowed it, and... Because can you imagine if the jury could ask questions in the YSL trial here? So, whatever happened in this case for Blalock, when questions were posed by the jury, so questions were, the jury could ask questions, Hartfield refused to answer whether she knew the deceased was shot in the car. So we don't know. Hartfield doesn't know if the deceased was shot in the car. But remember, it seemed like the story that we heard from Mariah Smith on the stand, and from what detectives understood, was the car was trying to drive away and they were blasting from the bushes at the car. So, and two, why Miss Mariah Smith stated that Miss Hartfield assisted in the planning of the deceased's death. So, Miss Mariah Smith testified that she knows all of the parties involved, and on the night at issue, she met with Brazy and Co-Indictee Ryan to travel to Appellant's home. At Appellant's home, Miss Smith heard Brazy telling a male over the phone that they would have sex with them, which she believes is what made the alleged victims travel to their location. A blue Dodge Charger then arrived, and she recognized BJ and the two other males in the car. Miss Smith then entered this Dodge Charger vehicle because she told them they could purchase marijuana as they were about to drive away, and Brazy then entered the car with them. Brazy entered the vehicle, returned 2 to 3 minutes later, grabbed Miss Smith, and walked off. A few minutes later, gunshots erupted, and Miss Smith observed Appellant running in one direction and Co-Indictee Ryan running in another direction. Miss Smith did not see Brazy with a gun, but did see Co-Indictee Ryan and Appellant possessing firearms and shooting at the car. Miss Smith hid in the bushes, and Co-Indictee Ryan exited a van, the van that they never searched for gunshot residue, and told Miss Smith and Brazy to get into the van, and the four of them returned to Appellant's mother's home. Co-Indictee Ryan gave Brazy money and locked Miss Smith inside Appellant's home. Miss Smith claimed that she was locked inside of Appellant's home when her mother called her cell phone and advised that the police were at the house wanting to meet with her. Didn't she testify that she called her mom? Was that outgoing? I could be shady on these details. It could be foggy for me, so... But wasn't that her testimony that she made the call? Called her cell phone. But didn't she not have her cell phone? She found a random phone in the basement? Okay. Miss Smith told her mother where she was located, and shortly thereafter, the police arrived at an area nearby, and Appellant Brazy fled. Miss Smith met with police and lied to them that evening because she was scared of Appellant, Co-Indictee Ryan, and their families. Miss Smith admitted to initially lying to police and asserted that her trial testimony was truthful and the video of the police interview was a lie. Miss Smith was fearful to testify because she received close to 100 threats, which she reported to a detective. Outside of the presence of the jury, defense counsel objected to witness intimidation testimony, which was denied by the trial court. There was no evidence that any threats were communicated to any detective. Miss Smith made contradicting statements to police about Mr. Mitchell firing a gun. Miss Smith admitted that she altered her version of events after Detective Hogan told her his theory on what happened the night of February 23rd, 2019. Miss Smith swore that she had shared all of the threats that she received with the detective and was surprised that the detectives asserted that they had not received anything from her on this case. Miss Smith explained that her testimony was truthful because she had nothing to do with these crimes. Remember the brain text where she's like, she apparently brought a screenshot of something and Hilton had it and it was just a screenshot. It wasn't in the records because they didn't look for her phone records. So they only had a screenshot that was provided to them, to the state. And she was like, oh, he also sent a rat emoji with a brain, but the rat's gone because he deleted it before I screenshotted it. So there was something with that too. Miss Smith explained that her testimony was truthful because she had nothing to do with these crimes. She met Appellant and Co-Indictee Ryan through another individual. She was not present when appellant and co-indictee Ryan were planning the events that day, and she simply walked into something she did not know about. At this critical time, Miss Smith observed co-indictee Ryan and appellant both shooting firearms. Miss Smith uttered that she did not know appellant or co-indictee Ryan and did not know anyone else who lived in the relevant apartment complex, but knew Brazy. City of Atlanta Police Department Detective Al Hogan was the lead detective assigned to this case on February 23, 2019. Detective Hogan learned that the vehicle involved had been stolen, and it appeared that the deceased had been killed while seated in the front passenger seat, and thus another individual drove this car. Detective Hogan obtained a statement from Mr. Mitchell, who described that he was with the deceased and Mr. Uten on the night of the shooting, and they started talking with Brazy, who invited them to drive to her location. They met up with Brazy and Miss Smith, who suggested that they purchase marijuana. The group drove to 50 Mount Zion Road, pooled their money, and Brazy exited the vehicle to presumably obtain the marijuana. Brazy walked away for a few minutes, returned, presumably with the marijuana, and then told Miss Smith to get out of the car in order to smoke with her. Mr. Mitchell then saw a man with dreadlocks wearing a hoodie with a long gun firing from the breezeway into the car. At this point, Mr. Mitchell attempted to drive, but the car did not move, and a second shooter appeared at the corner of the building. Eventually, Mr. Mitchell and Mr. Uten fled from the car, ran into another car, and they drove to a second location. Mr. Mitchell admitted that both he and Mr. Uten had guns with them. Detective Hogan testified that Mr. Uten corroborated much of Mr. Mitchell's claims, with the exception that Mr. Uten did not see a second shooter, possibly because he was laying on the floorboard. This sounds complicated. Ms. Smith identified the Instagram handles for co-indictee Ryan and appellant. Detective Hogan obtained search warrants for those Instagram accounts and interviewed co-indictee Ryan, who denied knowledge of the shooting. Detective Hogan interviewed appellant, who denied being present at the shooting. Mr. Mitchell never identified appellant nor co-indictee Ryan, as he only saw one man with a hoodie, dreadlocks, and a long gun, not a second shooter. Other than Miss Smith, no one else declared that there were two shooters. Neither appellant nor co-indictee Ryan had any fingerprints or DNA on the relevant car. Police did not locate any of the guns used during this incident. Detective Hogan admitted that Miss Smith was the only person who identified appellant as a participant in this crime, and she did so only after giving inconsistent statements for the first 2 hours of interrogation. Instagram records from the appellant, co-indictee Ryan, Miss Hartfield, and Mr. Mitchell were introduced, showing that the co-indictee Ryan and appellant appeared to have been together around the time of the shooting. After the shooting, Miss Hartfield sent a message to both appellant and co-indictee Ryan, stating that she and Miss Smith were speaking to police and that Miss Smith was snitching. Appellant responded to the message, "I knew that hoe was a rat, and what she say about me." Instagram conversations between Miss Hartfield and Mr. Mitchell were discussed. After closing arguments were presented, the trial court gave the jury a final charge, to which appellant interposed no objections. During deliberations, the jurors asked, "How should we interpret pleading the Fifth?" And the trial court, without objection, charged as follows. The Fifth Amendment to the United States Constitution guarantees that an individual cannot be compelled by the government to provide incriminating information about herself, the so-called right to remain silent. When an individual takes the Fifth, she invokes that right and refuses to answer the question or provide information that might incriminate her about this case or any other. How this concept factors into your fact-finding and ultimate decision is for you to decide. Appellant and co-indictee Ryan were found guilty on all counts submitted to the jury. Now there's a footnote. Counts 1 and 5 were null prost. Appellant, as well as co-indictee Ryan, was sentenced to life plus 25 years to serve in prison. At the time of filing brief of appellant rots in the state of Georgia prison system. So now we're going to get through enumeration of errors. We're going to see some of the arguments. But what we got so far was, I think, kind of the best look at what happened at the trial court, in the trial court for this case. Right? So what we saw in the YSL trial were these witnesses being called to testify once again. And really why I think both Leah and Mr. Williams were on fire is some of this stuff, the little bit that we get to see here in this, what was that, like 11 pages? Maybe less than that. There's a few things that I was like, hey, wait, the testimony was a little different. Un poquito. So what are you guys thinking? And if court hasn't started, right? All right, no, it's still like on the random symbols. If there's time, if we get through this, I want to see what they lay out these arguments are. But we could replay the Mariah Smith testimony. We could listen to some of the evidentiary arguments, look back at Al Hogan, of course, the cross by Ryan's counsel. But some of this is just, I don't know. It's a little weird that you've got someone turning on the other girl, someone else who's friends with the other girl, kind of, because Mariah Smith was like, I knew BJ, I knew him since school, but she seemed uncertain of how to characterize him. This guy BJ is writing a note like, Rodalius Ryan is innocent. It's not indicated here that Blalock is innocent, right? This is the appeal for Blalock. This isn't for Ryan. Just, of course, it overlaps. The facts of the trial overlap. But that note about innocence only mentioned Ryan. Right? So there's a lot of interesting little bits here. Oh, sorry, let me reshare the link for this. It needs permission to be shared. My bad. I do that a lot. Sorry. I probably made the same mistake for all of them. Oh my gosh, I do this every time with Google. All right, let me make them all. All right, I scrolled up, right? I have to scroll back down. All right, part 2. Let me take a sip of something. Was kind of losing my voice yesterday. And I planned to read this yesterday when there's no court. I think tomorrow is a pre-planned day off of court, I believe. So I was like, okay, we can do this Friday. But then nothing happened today. So here we are. So we're just going to see if the vocal cords hold up. Part 2, the enumeration of errors. Get my pumpkins off the screen. First, appellant's trial counsel. Remember, this is Blalock. This is the appeal brief by Brian Steele for Blalock. Appellant's trial counsel rendered deficient performance by failing to understand prevailing laws that were critical to a witness invoking her constitutional right to remain silent in front of the jury. This deficient performance prejudiced the outcome of appellant's case, and hence, appellant's convictions and sentences must be reversed. So, I'm assuming they're talking about Mariah Smith. Appellant's trial counsel rendered ineffective assistance by failing to fully object when the prosecutor intentionally commented on appellant's failure to explain where he was located at the time of the indicted crimes. Hence, appellant's convictions and sentences must be reversed. Oof. And there's, it seems like the same issues were there for Ryan. Did they have the same trial counsel? Because sometimes people will waive that conflict and be tried together with the same counsel. I mean, I guess we'll see that argued here. And 3, appellant's trial counsel rendered ineffective assistance by failing to realize that evidence existed to disprove the state's theory of the case. Hence, appellant's convictions and sentences must be reversed. 4, if this honorable court does not find that issues number 1, 2, and or 3 are strong enough individually to reverse appellant's convictions, appellant also raises a cumulative effect of multiple error test. So let's get into these. So the first one is going to be, the trial counsel was deficient by failing to understand prevailing laws that were critical to a witness invoking her constitutional right to remain silent in front of the jury. This deficient performance prejudiced the outcome of appellant's case, and hence, appellant's convictions and sentences must be reversed. Standard of review. Whether the trial court's finding that appellant's trial counsel did not render ineffective assistance is reviewed under the clearly erroneous standard for factual issues and de novo review for legal issues. So, a mix of both. So it's going to be new in some regard, but it's clearly erroneous by some standard. Let's see what those are. And this is Steele, guys. This is Steele making these arguments, and his team. This enumeration of error is preserved for appellate review as the appellant raised this issue at his earliest opportunity, to wit, the motion for a new trial hearing. And they cite the transcript from that hearing, and they cite here Hood v. State. At the time of appellant's trial counsel, 1, had never tried a felony case, save 2 drug cases. 2, had no second chair to mentor or consult with appellant's capital case. 3, yeah, so you're running a capital case. You don't have a second chair there with you. And this is your first felony case of this kind. Your only other felony cases were 2 drug cases. So that's what Blalock was with at the trial level. And 3, had no understanding of critical bedrock law set forth in Bruton, the Confrontation Clause, or the applicable law concerning a witness who invoked her Fifth Amendment right in front of the jury. And 4, had no understanding of the harmful error the trial court committed with its erroneous instruction on how jurors can use the witness's invocation of the Fifth Amendment during testimony. Oh boy. Look at all this transcripts to go through to match up here. The relevant facts. In the case at hand, outside the presence of the jury, the lawyer for Miss Hartfield, a critical witness, made it known that her client would invoke her constitutional right to remain silent if called to testify before the jury. Remember, Hartfield is Miss Brazy, Tahira. Therefore, Miss Hartfield was called by the prosecution to testify without any meaningful objection from appellant's trial counsel. Specifically, the following testimony was presented to the petite jury. Good morning, Miss Hartfield. How are you? Good morning. I'm good. Do you know where 50 Mount Zion Road is? Yes. Have you ever been to 50 Mount Zion Road? I plead the fifth. You plead the fifth. Did you ever go by any other nicknames? No. Have you ever gone by the nickname Brazy? No. Oh my god. Has anyone ever called you Brazy? No. Do you use Instagram? I plead the fifth. You do use Instagram? I plead the fifth. Oh, you plead the fifth. I'm going to show you a picture. Can you tell me what this is? Instagram. Is this your Instagram account? I plead the fifth. Have you ever heard the name Ryan? I plead the fifth. Judge, we would inquire, and you see there's no... This is just witness, prosecutor, and we're finally getting the court. Judge, we would inquire as to how that would relate to the Fifth Amendment, hearing a person's name. I'm not asking at this point if she knows him. I'm just asking if she ever heard the name. Trial court says privilege is sustained. Have you ever heard the name Damone Blalock? Witness, yes, I went to school with him. Have you ever heard of Mariah Smith? Yeah, I went to school with her too. Okay. Have you ever known anyone to go by the nickname Lil Rod? I plead the fifth. Have you ever known anyone to go by the nickname Bali? I plead the fifth. You said you know Damone Blalock? I went to school with him. You went to school with him. Can you identify him in the courtroom by telling me where he is sitting and what he is wearing? The bow tie, something indistinguishable, with black on. How long have you known Blalock? For about 2 or 3 years. About 2 or 3 years. Okay. Do you know where the defendant lives? I plead the fifth. Prior to today, when is the last time you saw appellant? I've been incarcerated. Okay, but prior to today, when was the last time you saw appellant? I plead the fifth. Okay, have you ever heard the name Bernard Mitchell? No. Have you ever heard the name Rodney Uten? No. Have you ever heard the name of, and I'm assuming Jamari Holmes? I plead the fifth. Do you know a person whose government name, whose real given name is Bernard Mitchell, who goes by the name BJ? No. Do you know anyone by the nickname BJ? No. Do you know anyone who goes by the nickname Red? No. And I'm recalling what has previously been admitted as State 378. Do you know who that person is? No. Okay, I want to talk to you about the date of February 23rd, 2019. Do you remember that day at all? I plead the fifth. Stop it. Guys, how is this going and going? Oh, gosh. Oh, my goodness. What a mess. Like, how many times are they going to plead the fifth and, the counsel is not saying something? Like, this is a little crazy. At some point that day, did you meet up with Blalock, who you've already identified in court, also known as Bali. I plead the fifth. And, you know, this is like a trick question. You would think that defense counsel would object here too, but whatever. I plead the fifth. On that day, did you meet up with Co-Indictee Ryan, also known as Lil Rod? I plead the fifth. On that day, did you communicate with anyone through Instagram? I plead the fifth. On that day, did you communicate with Bernard Mitchell, Rodney Uten, or Jamari Holmes via Instagram? I plead the fifth. On that day, did you arrange for a meeting with you and Mariah Smith with Bernard Mitchell, Rodney Uten, and Jamari Holmes? I plead the fifth. Can you explain to us what was the reason for meeting with those individuals? I plead the fifth. On that day, did you attempt to facilitate a purchase of marijuana for Bernard Mitchell, Rodney Uten, and Jamari Holmes? I plead the fifth. On that day, did you get into a blue Dodge Charger with those same 3 individuals? I plead the fifth. Oh my gosh, I need a button. On that day, did you drive with those individuals to 50 Mount Zion Road? I plead the fifth. On that day, did you get out of the vehicle, leaving those 3 individuals and Mariah Smith in the car? I plead the fifth. On that day, did you come back and get Mariah Smith out of the car, leaving only the 3 boys in the vehicle? I plead the fifth. How long did you know Mariah Smith? Only for a couple years. Would you call her a friend? No. Would you call her an acquaintance? No. How would you describe the nature of your relationship with you and her? Nothing. Have you made threats to Mariah Smith? I plead the fifth. After Mariah Smith left the car, do you know what happened that night? Trial counsel finally makes an appearance. Holy moly. Objection, Your Honor. Assumes facts not in evidence that Mariah Smith left some car. Trial court overruled. There has been testimony about females getting out of the car by at least one other witness. Prosecutor, after Mariah Smith left that car, do you know what happened? I plead the fifth. Okay, did you come back for Mariah because she's your friend? I plead the fifth. Did you come back for Mariah so she would not be injured in some way? I plead the fifth. Did you see the shooting that occurred that day on 50 Mount Zion Road? I plead the fifth. Did you shoot anyone that day on Mount Zion Road? I plead the fifth. Did you have a gun in your hand on that day on Mount Zion Road? I plead the fifth. After the shooting on Mount Zion Road, did you and Mariah Smith leave that location? I plead the fifth. After leaving Mount Zion Road, were you and Mariah Smith picked up by law enforcement? I plead the fifth. After leaving Mount Zion Road on February 23rd of 2019, did you speak to any law enforcement individuals regarding this case? I plead the fifth. After speaking to law enforcement and after the shooting on Mount Zion Road that day, did you communicate with anyone via Instagram? I plead the fifth. More specifically, did you communicate with Co-Indictee Ryan? I plead the fifth. Did you communicate via Instagram or through some other channels with Blalock? I plead the fifth. Did you communicate through Instagram or some other channels with Mariah Smith? I plead the fifth. Oh, I'm tired of hearing myself. Did you communicate with Bernard Mitchell? I plead the fifth. And did you communicate with Rodney Uten? I plead the fifth. I'm approaching you with 2 documents. Do you recognize the document? I plead the fifth. After leaving Mount Zion Road, did you make a phone call or receive a phone call from the victims asking about the shooting? I plead the fifth. Judge, at this time, the state would recall States 381. That is the audio recording presented to in court yesterday by Mr. Bell. Permission to publish, Judge? Granted. Thank you. So the exhibit plays. Okay, in that video, we hear a person on the phone say, huh? We hear the person in the video say, why they shoot at us? We hear the person on the call say, 'cause they said that y'all was parked in front of the spot. They said that y'all and let that smoke weed. There is a pause. You hear the person in the video say, why you capping? I don't even know these and astophonetic. Oh, so they're spelling this horribly, but I'm not going to figure it out for you guys. You guys got that one. And then we hear the voice on the phone saying, on my auntie, that's what they said, BJ. I'm just the voice on the phone. Is that you? I plead the fifth. Can you tell me what capping means? Lying. Lying. Okay. Can you tell me what the spot means? It's a place, like it's the house. It's the location. Yeah, the location. Okay. Have you ever heard of a neighborhood referred to as the Ville? Yeah, Mechanicsville. So they continue to play the video. On that video, we see the person in the video say, what you say. The voice on the other end of the call says, You trying to seem like you intelligible. It was up to me. Then we hear the individual in the video say, what you say? Then we hear the voice on the phone say, I didn't set you up, but you sound like you going to do something to me. Then we hear the person on the video say, then there's a pause. Then we hear the person on the video say, wait, well, tell her I'm a move, and then she locks shit up. Do you recall that conversation? I plead the fifth. So I'm assuming this is Mariah that she's speaking with because it says she. Is that your voice on the phone? I plead the fifth. Do you know the person in that video? I plead the fifth. Have you ever made an Instagram phone call? I plead the fifth. When is the last time you had communication with Mariah Smith? I plead the fifth. When is the last time you saw Mariah Smith? I plead the fifth. Oh my God. Did you know what was going to happen to those boys on February 23rd, 2019? I plead the fifth. I have nothing else for this witness at this point, Judge. Thank you. Trial court. Cross-examination. And then now we're getting to Rodalius Ryan's trial counsel. Okay, so they have separate counsel. Thank you. Good morning, witness. Good morning. Do you own a gun? I plead the fifth. Did you own a gun back in 2019? I plead the fifth. Has anyone threatened you about this case? Yeah. Who's that? A boy who I don't know him, but it'd be a lot of people, but I don't be worried about it. Okay, has Ryan threatened you? Who? Has Ryan threatened you? Who's Ryan? You don't even know who that is? No. Okay, has Blalock threatened you? No. Has Mariah Smith threatened you? A couple times. No further questions, Judge. Cross-examination. So now this is Blalock's counsel. Did you set up Red, BJ, and the deceased to be shot at? No. Were you at the same apartment complex when they were shot at? I plead the fifth. Did you direct appellant and co-indictee Ryan to shoot up their car? No. No further questions. Redirect? Briefly, Judge. Now, a moment ago, you were asked if you were being threatened, and you said you were. Yeah. Okay, what were the nature of those threats? That they're gonna kill me? That they're gonna kill you with what? They're gonna kill me because they think I set them up, but I didn't. So these people are threatening you because they think you shot up the deceased being shot, Jamari Holmes being shot. Yeah, because that's what Mariah Smith told them. No texts, no emails, nothing other than in-person threats from people that you see around your neighborhood. I plead the fifth. Okay, the people who are threatening you, do you actually know who they are? No. Okay, but you don't know Ryan. I plead the fifth. And you don't know Bernard Mitchell. I plead the fifth. And you don't know Rodney Uton. I plead the fifth. And you don't know Jamari Holmes. I plead the fifth. Okay, I have no other questions at this point, Judge. Thank you. All right. And then I think Ryan is doing recross. Ryan's counsel is doing recross. I don't want to put words in your mouth, ma'am, but I do understand that your testimony is that the people who threatened you believe that you had set the victims up. Is that right? Yes. Okay, you have not received any threats about your testimony in this case, right? No. All right. No one said don't come to court and testify? No. No one has threatened you about that, right? Nobody know I was coming to court. Thank you. And then Blalock doesn't have recross. And then we get jury questions. We have some jury questions. Okay, wait, there's a footnote here. The trial court permitted the jury to submit questions to ask witnesses. Okay, so yeah, the judge made this determination here. So what are these questions from the jury after this testimony? The first question from the jury. Did you know that Jamari Holmes was shot in the car on February 23rd? I plead the fifth. Next question. Why does Mariah say you set Jamari Holmes up? I plead the fifth. Okay, last question. How do the people who are threatening you know Jamari Holmes? Because he young, everybody know everybody. Everybody done went to school with everyone. Even if you don't know somebody, they know someone who knew them. Something like that. And then the witness leaves the stands. And then we're back to different arguments here. So that was a pretty interesting transcript of how Tahira Hartsfield, aka Miss Brazy, doesn't know that she went by the name Miss Brazy ever. I plead the fifth. Miss Brazy, I plead the fifth. That was a peek into her testimony because we didn't have her testify in the YSL trial. So that was pretty interesting, even with all the I don't recall. I mean, I plead the fifths. What do you think of the jury questions? I mean, they're kind of asking exactly, there's some confusion about the car. Were they in the car? Did they get out the car? Were they shot in the car or while they were moving out and about? Why does Mariah say you set the Jamari Holmes up? How do you know the people who are threatening you? Like, these are questions that I think the chat would also ask, right? So, also big shout out to Classy Gang. I see Classy Beats in the chat. Good morning. Classy, if you want to, if you want to read I Plead the Fifth 17,000 times for a video, it is in the description of this video. Anyone joining that's new, this is Brian Steele writing the appeal brief for Damone Blalock. Remember, that was the co-defendant of Rodalius Ryan for the Jamari Holmes murder trial. So this is his appeal brief for his client, Blalock, but we're getting some insight into what Rodalius Ryan's counsel did as well through this transcript. So this is a time. Oh, man. I never want to hear the phrase, I plead the fifth again. But now we're going to get back to further down in the trial, some relevant issues here during jury deliberations. This is some stuff that occurred. All right, good morning, everybody. All parties are here, defendants included. The jurors have two questions. The first question is, are counts 2 and 10 also subject to conspiracy, the possession of firearm and the murder, non-felony? Oh my God, can you imagine the YSL trial jury, the questions they're going to have about jury instructions? Now, we haven't seen mid-trial questions from the jury, but when it comes to mid-trial questions, but when it comes to deliberations, if the jury has questions about understanding the instructions, even though we're not getting questions from them during the trial, they will be able to ask questions then. So can you imagine the amount of questions we're going to get from the jury about this mess? Even if it's only these 3 defendants. Their second question here is, how should we interpret pleading the fifth? I will mark these questions as Court's Exhibit 12. Then we also have from the trial court from the judge. Second question, how shall we interpret pleading the fifth? What I propose is to explain the fifth as follows. Except I might be willing to say, if everybody is in agreement, let me start from the beginning again. The Fifth Amendment to the United States Constitution guarantees that an individual cannot be compelled by the government to provide incriminating information about themselves, the so-called right to remain silent. When an individual takes the fifth, she invokes that right and refuses to answer questions or provide information that might incriminate her about this case or any other. How this concept factors in your fact-finding and ultimate decision is for you to decide. Prosecutor, I think that works. Ryan's counsel, I think that's great. Blalock's counsel, that's fine. So the judge says, all right, everyone be seated. Good morning. Okay, let me answer some of the deliberating jury's questions first. How should we interpret pleading the fifth? The Fifth Amendment to the United States Constitution guarantees that an individual cannot be compelled by the government to provide incriminating information about herself, the so-called right to remain silent. When an individual takes the fifth, she invokes that right and refuses to answer questions or provide information that might incriminate her about this case or any other. How this concept factors in your fact-finding and ultimate decision is for you to decide. So I don't think that was different. I think they just have to have that in the record that it was read to the jury for this appeal. Relevant law. So this is where we're going to get into Brian Steele's favorite thing. It is an accepted practice for the trial court to never allow a witness to invoke her Fifth Amendment privilege in the presence of the jurors, as the jurors must not draw any inference, either alone or in conjunction with other evidence or the questions posed to the witness, that the invocation of this constitutional right somehow harms the criminally accused on trial. So, Brown v. State, Billings v. State, Davis v. State, United States v. LeCouture. So, bunch of sites there. Jurors cannot be placed in the position where they use the invocation of a witness's Fifth Amendment rights against the criminally accused, because neither the prosecution or the accused should be benefited or damaged simply by the witness's exercise of her constitutional right to remain silent. So, Billings v. State and Davis v. State. Depending upon the circumstances of the testimony, a witness's invocation of the fifth in the presence of the jury could deprive the criminally accused of his constitutional right to confront that witness. That's Cody v. State and Fuller v. State. So two different arguments here. Like, one issue is the witness might have the right to exercise their right to remain silent, but neither party should be benefited or damaged by this. So the solution here is keep it away from the jury. Don't put a witness up on the stand who's going to invoke their Fifth Amendment right. The second issue is when they're invoking their Fifth Amendment right, especially when it's continuous, multiple times, you can't confront that witness about certain facts. And when they're invoking it in response to almost every question, you can't really confront the witness about most facts. So a second argument Steele is making here is this confrontation issue. It's worth noting that this privilege asserting witness being called to testify before appellant's jury is so imbued with the potential for unfair prejudice that a trial judge should closely scrutinize any such request, as the prosecutors continued extensive questioning of Ms. Hartfield after knowing that she would assert the privilege of self-incrimination was harmful to appellant, especially coupled with the above-quoted erroneous jury instruction. So United States v. Vendetti, United States v. Maffei, United States v. Johnson. Ms. Hartfield's refusal to answer core questions about the facts in the indictment violated appellant's confrontation clause rights. Horne v. State. As quoted above, this witness invoked her right to remain silent on critical questions that were adverse to appellant's liberty. Specifically, the witness invoked this privilege as to critical inquiries, including, but not limited to, whether the witness, 1, was with appellant, so Blalock, on this fatal date, 2, threatened Ms. Smith, who implicated appellant in this murder, 3, saw this shooting, and 4, communicated with appellant on Instagram a short time after the shooting. The fact that these questions were unanswered by pleading the fifth led to the inescapable conclusion that Ms. Hartfield's responses would incriminate her as well as the appellant. There you go. These questions and non-answers harmed appellant's liberty and denied appellant his right to confront this witness. This constitutional error was magnified by the trial court's instruction to the deliberating jury to use this invocation for the fact that Ms. Hartfield's answer might incriminate her about appellant's case, this case, or any other case. There we go. I didn't catch it until it was just spelled out. That's why. It might incriminate her about this case against Blalock and Ryan. What's the inference there? That there's criminality for what's being charged here, this indictment. Or any other case, and how this concept factors into the juror's fact-finding and ultimate decision is for the jury to decide. This instruction wrongly empowered the jury to find that Ms. Hartfield's Fifth Amendment assertions would incriminate her in these indicted crimes, and that the jurors could use that inference of guilt in reaching their verdict on Blalock's liberty in this case. Oof. Now I see why they had to include what was... So this is why they had to include it twice. Because it's really two issues here, right? The trial court, the jury instructions, the judge reading this is one error. But the fact that the counsel didn't object to it is a second error. Counsel could have objected and they failed. So there's a deficient counsel argument here, as well as a jury instruction, what actually was finally charged to the jury. Right? So definitely important to have both of these parts in here. Let's see. Right, I ended up... Where were we? Think here. There was simply no strategic or objective reason for appellant's trial counsel not to object to the witness's invocation of her Fifth Amendment in front of the jurors. I mean, how did you guys feel when we were going through that transcript and it was how long before we heard anything from trial counsel? And the objection was just mischaracterization of whether someone was getting in or out of the car. So, but what's the issue here? I see mention of Woody, if you guys are just tuning in, earlier in the beginning of this brief, there's a footnote that tells us, yes, the prosecution said you could be held in criminal contempt, but what's the problem? What's the problem for Miss Hartfield? Miss Hartfield was already in custody at this point in time. So, all right, you hold me in contempt. It's no different than where I'm sitting at when I leave anyway, right? So not really a solution to try to compel somebody. So then the prosecution puts this witness on the stand anyway, and they're just blurting out, I plead the fifth a million times. And then on top of it, it's a problem that the prosecution did that. But defense counsel didn't object. So, oh man. There was simply, let's see, likewise, there was no objectively sound reason not to object to the trial court's objectively inaccurate and harmful charge on how the deliberating jury could employ this Fifth Amendment's invocation. Miss Hartfield's Fifth Amendment assertion was not beneficial to appellant because it could reasonably appear that she was a co-conspirator of appellant and thus refused to admit her and appellant's inculpatory conduct. This non-testimony, coupled with the jury instruction, which green-lighted the use of that invocation against appellant by the jurors in reaching their verdicts, is both deficient performance and prejudicial to the outcome of appellant's case. Now, this is like, I don't know, but this is why I love reading appeals. I'm like, wow, I never would have thought. I get it while I'm reading it. But it teaches me how to see two issues and how they stack together. The jury instructions given by the court, the judge is giving the green light. So for Steele to argue here, you take her saying, I plead the fifth on something that sounds shady as heck, and then you green light the jury, you empower the jury. You say, you know what? You're asking me as a question during deliberations. The jury wants clarification. So this instruction isn't just an instruction people are tuning out as part of a huge thing. It's an instruction being given in response to a request for understanding. So probably something the jury's paying attention to and putting a lot of weight in. And the wording of it says, you can infer what you want of her saying, I plead the fifth about this case that involves these two men. You can infer what you want from it. The ultimate decision is yours. So to see someone like the wording here is so good. It's so good. Steele says this non-testimony, coupled with the jury instruction, which green-lighted the use of that invocation against Blalock by the jurors in reaching their verdicts, is both deficient performance and prejudicial to the outcome of the appellant's case. I think this is a really strong argument. I'm not an appellate judge, though. What do I know? As argued above, Ms. Hartfield's invocation of her Fifth Amendment right to remain silent cannot be used as a weapon against appellant, but the jury was wrongly instructed to the opposite. He cites Davis v. State, State v. Wakefield. Neither the state nor the accused is permitted to benefit from the witness's invocation of privilege against self-incrimination. So, if we were going through that and you're thinking to yourself, all right, she pled the fifth to like everything though. Some of the answers could be bad for the state. Some of it could be bad for the defense, but doesn't it kind of even out? Doesn't matter. Case law says it shouldn't matter. So, the witness's assertion of the Fifth Amendment in front of the jury, coupled with this clearly erroneous jury instruction, permitted the jury to conclude that Ms. Hartfield was protecting appellant, a guilty person. This negative inference created by the trial court's instruction is wrong because innocent people invoke the Fifth Amendment. Appellant's confrontation clause and due process rights were trampled upon because the jury would logically infer Ms. Hartfield was protecting appellant, a guilty person. In conclusion, the laws and facts cited above mandate a finding that appellant's trial counsel rendered deficient performance by being unaware of the law on this critical issue. The evidence of guilt presented against appellant was not overwhelming. See entire trial transcript. For instance, neither of the victims, Mitchell or Uten, identified appellant as a perpetrator. 2, there was no scientific evidence to connect appellant to these crimes. We heard in the YSL trial from Hogan, we didn't look at the van they told us about right away, that they all got in. We didn't look at the van for gunshot residue, right? So no scientific evidence there. 3, Miss Smith was the only person who identified appellant as a perpetrator, and Miss Smith made multiple inconsistent statements. 4, appellant denied being present at this shooting scene. And 5, there was no video surveillance captured of this shooting. Although Instagram conversations were introduced that showed appellant interacting with Co-Indictee Ryan and Ms. Hartfield about this event before and after the shooting occurred and during the police officer's investigation, that evidence should respectfully not be deemed sufficient for finding of a no prejudice under Strickland v. Washington. Based upon the above, appellant's convictions and sentences must be reversed. So, next argument here. What do you guys think about first block that we just went through? Hey, Red Bunny. Oh, I love you, Rice Street. Rice Street saying, thank you to PD Broker, but I come to the kattnotwilliams chat because it's a safe place. See, shout out to the mods. The mods make this a great and warm, welcoming place to everybody, even Rice Street. But we do love this Rice Street. We love this Rice Street. Love to see it. Shout out to the mods. And I'll do let's do a routine check. Let's see. No, nothing on X about this is what we've got. Rumors of rumors, but nothing I'm willing to report. So there we go. Love the way that that's worded. I agree. I agree. Shout out to Jim R in the chat. Did you just get here? Were you able to catch some of this briefing? Ike says, okay, let me make this bigger. My screen is real tiny. Ike says, I think her counsel was working with the state. So, and I think they did give us the attorney's name. So we're on page 42. We'll come back. Because I remember pronouncing it. They probably use counsel. Callier or Callier. So this is Hartfield's counsel. I think her counsel was working with the state and that they get away with this in Atlanta because of the ocean's depth of IQ differences between attorneys and its citizens, like ranchers and cattle. Yeah, and I would argue that there is, if she was in custody and maybe this is the same counsel, I mean, I wouldn't be surprised if there were some under-the-table benefits conferred to Ms. Hartfield that, oops, the state didn't disclose over to the defense in this case. Would anybody be surprised by that? Benefits conferred to Ms. Hartfield, who gets up there and still pleads the fifth anyway. But maybe like, hey, you're already in custody, but we could work with you on that. Like, who would know? Because why would the state disclose that to the defense, even though they're absolutely supposed to, So I'm with you. Shout out to Ike. Good to see you, Ike. We've also got, let's see here. Aw, Partially Stars, thanks for the 2. Giving a thank you to whoever gifted my membership. Got a ton of gifted memberships today. Kicked off with FFS. STS has dropped some. Daniel Judge, Survivor Speaks. Peter Ortiz. And then we also have 5 from here from Iron Rabbit. So you might have gotten one from Iron Rabbit. These are real close here. So thank you for saying thank you. Thank you for the 2. Iron Rabbit, thank you for gifting 5. Good to see you today and hope you're doing well. And, worth repeating again as people come in and out, I don't have any information on potential pleas. Just seems like negotiations might be ongoing. So that's what I've got. And I think let's up this count here. We should have this right. So big thank you again to Iron Rabbit. Yeah, and this is kind of how bathroom deals instead of backroom deals. Hey Nisha, good to see you. Okay, Grammar, sadly, shady convictions are the norm in Fulton County. And again, probably not isolated there. Right. Court, come on, get a move on, court. Tell the people what's happening. Nah, negotiations are complicated, you guys. Yeah, this is the wording, right? I can confirm that certain defendants may be considering entering into a plea agreement. Chloe Albert's Revenge says, breaking news, I Plead the Fifth, the new single by Young Thug. Featuring Brazy. Imagine she's featured, she's in the video, and they go, have you ever gone by Brazy? And she's like, I plead the fifth. On NTGLT. Okay, I don't know. I'm slow on that one. Records. Get your copy now. 10% off when you enter the code RICO with the amphibious green emoji. Oh, man. No, and no updates, you guys. If you're just coming in, I don't know if I said this before or after you got here. No updates. Just, probably negotiating pleas or trying to negotiate pleas, considering pleas. So, won't know anything till we know. Oh, not guilty records. Okay, my bad. I was like trying to think that each letter stood for something. I didn't realize the vowels were just gone. And at first I was like, nightly? I don't know. Thank you guys for the assist out here. It was much needed. Oh my goodness. Kokomo, I think, be trolling. You guys gotta watch out for Kokomo's tweets. And do you guys have alerts on for Kokomo tweets? What are you guys doing out here? Oh, man. Hold on, let's get to this argument, too. I think it was like page 40 something, right? Okay. Get rid of my search. And you guys know the drill. If court starts, just spam something in the chat. Like the giant, I don't know, the heavy breathing cat emoji. Spam those in the chat if court starts. We'll switch over to it. Let's see. Appellant's trial counsel rendered ineffective assistance by failing to fully object when the prosecutor intentionally commented on appellant's failure to explain where he was located at the time of the indicted crimes. Hence, appellant's convictions and sentences must be reversed. So, standard of review, whether the trial court's finding that appellant's trial counsel did not render ineffective assistance is reviewed under the clearly erroneous standard for factual issues and de novo review for legal issues. This enumeration of error is preserved for appellate review, as same was raised at the earliest opportunity, this motion for a new trial. A prosecutor has no lawful right to comment on the criminally accused failure to testify or post-arrest silence, as these are constitutional and statutory privileges provided to each person in Georgia and throughout America. See the 5th, 6th, and 14th Amendments of the United States Constitution. Article 1. I always love getting cites to the Constitution. Like, every time I see a citation to the Constitution, I just imagine someone, holding up a piece of paper hello? Excuse me. So, see the 5th, 6th, and 14th Amendment to the United States Constitution. Article 1, Section 1, Paragraph 16 of the Georgia Constitution, OCGA 24-5-505A, and we get some case law. So Jackson v. State, Ammons v. State. In the case at bar, without complete targeted objection, the prosecutor posed the following questions to the petit jury during summation. So I would assume closing arguments here, right? You guys heard me talk this morning. Closing arguments. The frontier that prosecutors often think that they can say things that they're not supposed to say at trial because they do get a little more leeway in closing arguments and opening statements. They get a little more leeway. But a lot of prosecutors seem to take leaps and bounds here. And you heard me say this morning, I just have a feeling somehow, in her summation, Love would try to, in the YSL trial, Love would try to give the jury some hint. You know, you should go find Jeffrey Williams guilty of count 1, RICO, conspiracy to violate RICO, and somehow hint that the others have pled guilty to that count. Somehow I think she's just gonna do it. So, speaking of doing too much in summation, let's see what happened here for Blalock. So, prosecutor here says, I'm going to sit down in a second, and I believe Co-Indictee Ryan's counsel is going to get up first, and I believe Blalock's trial counsel, well, they don't have to get up and deliver closing arguments if they don't want to, but I think they're going to. No different than anything else. They carry no burden in this trial. As they are talking, I want you to listen for an answer to these 2 questions, and these are 2 questions that have sort of been sitting up there, I think, for this whole time. If they were not committing the murders, where were they? Okay, wait. Oh, wait. So Rodalius, Ryan. Okay, we get the objection. Thank God. Oh my God. Prosecutors are so extra. Why would they do this? Put a 1 in the chat if you caught that this is burden shifting. Why would a prosecutor do this? Luckily, both trial counsel object here. But like you guys in the chat, right? We're lay people. And this sent off a red flag immediately when I read the words. Why would they do this? They cannot be dumb, right? They cannot be dumb. So Nick, what they're doing here is they're shifting the burden. Right after they talk about, they're acknowledging that the defense doesn't carry the burden. 2 sentences later, they're saying, think about this. If they were not committing the murders, where were they? That's the state's job to prove beyond a reasonable doubt that they were committing the murders. They're shifting the burden. So luckily, Ryan and Blalock's counsel both object here. Judge, I'd object to burden shifting. I would object, Your Honor. They don't have the burden to prove where they were. Prosecutor, Judge, 1, what the attorneys say in closing is not evidence. 2, I preface it with the fact that they carry no burden. And 3, I also said they do not have to answer this question. Trial court overrules the objection from counsel. Prosecutor, if they weren't committing the murders, where were they? They are both saying they weren't there. Tell us where you were. We didn't hear any evidence of it, obviously, but I would still like to hear that. So now Blalock's counsel objects again, Your Honor. That's sustained. Thank you, Judge. Tell us where they were should be disregarded. So jury's supposed to just disregard that. Prosecutor, thank you, Judge. Now, in a minute, they are going to get up and they are going to present their summation to you again for however long their side takes to tell you what they think the evidence shows. And then I'm going to get up, and it's going to be a pretty long time for me to get up here and explain what we carry the burden, so we have to show you everything. We can't hide anything. We can't put anything aside. I have to address just about everything that comes up in the trial. So my second closing is going to be a whole lot longer than the first. But again, just use the tools at your disposal, use your common sense, think about what you actually heard on the stand. That's testimony. What I just said is not testimony. Focus on what we're here for, what we actually saw. Thank you. So it seems to me like the prosecutor's whole strategy is, let's do this burden shifting, but couch it between things that say, we're not burden shifting, but if they were committing the murders, where were they? But again, we're not burden shifting, what we're saying is not testimony. We have to tell you everything. We're going to bolster ourselves a little bit here. But because we're going to say we're not going to burden shift, we're going to sneak in this question that's really burden shifting. Like, come on. Just dirty. I'm telling you, this is exactly the type of mess I imagine in closing in the YSL trial. So then they skip to the final summation, right? They're at the prosecutor's final summation here. Okay, good afternoon, everyone. I hope you all had a nice lunch, a little bit of a break. I do have a lot to go over. I'm going to try to go over it as effectively and efficiently as possible. So before we left, I had an aside. I listened for an answer. I wanted to hear the answer to these two questions. If they weren't committing the murders, where were they? And if they are not guilty, why do they care about a snitch or a rat? You listened to both defense attorneys speak. At any point, did you hear an answer to either one of those questions? I did not, because they can't. They can't answer these questions, because the answer to the first one is that they were committing this murder. The purpose of the prosecutor's statement was to exploit the facts that appellant did not testify at trial and did not introduce post-arrest evidence proving his whereabouts at the time of the commission of these crimes. The prosecutor's intention was clear and unequivocal when it was argued. Blalock is saying he wasn't there. Tell us where you were. This statement unmistakably explains the mindset of the prosecutor to impermissibly comment on the appellant's right to remain silent and not put forth evidence. Compare Scott v. State. It was permissible for the prosecutor to comment on Mr. Scott's failure to call his mother and grandmother as alibi witnesses, since Mr. Scott told the investigator that he was with these family members at the time of shooting. So Steele is saying, contrast this. It would be different if Blalock had spoken to the officers and said something, and then chose at trial not to pull forth that thing they said. Oh, I have an alibi, it's this. And then at trial, well, they said that they had an alibi. And then in closing, you could say, well, we heard from other witnesses that they said they had this alibi, but we didn't actually see that alibi come forth and testify. We didn't see the defense present any evidence of that alibi. That's different than what's happening here. Blalock never sat with police and gave a statement that said, I have an alibi, and then didn't end up presenting that alibi at trial. So this is a layered argument here. Shout out to Brian Steele. He's carving out that the prosecutor could only be making a statement about a lack of a pre-arrest statement, which you're not supposed to do. This prosecutorial argument is harmful error. Guys, I am excited to watch oral arguments on Tuesday. This is scheduled for Tuesday. We'll watch it on lunch break for the YSL trial. If there is a lunch break, I'm really excited now to see Brian Steele out loud arguing this. While the trial court instructed the jury to disregard, tell us where they were. Even with this instruction, the jury would naturally understand the prosecutor's remarks during both parts of his closing arguments to be a direct comment on appellant's failure to testify at trial and or make post-arrest statements explaining his alibi. So they say, see Kirkland v. State. As quoted above, the prosecutor stressed that appellant's claim that he was not guilty of the indicted offenses demanded that appellant, 1, bring forth evidence, and 2, answer the prosecutor's questions as to where he was located at critical times of commission of the crimes. This argument, in toto, violated appellant's above-referenced constitutional and statutory rights and the failure to object to comments critical of appellant's failure to testify and introduce evidence was deficient performance. Specifically, the objections of trial counsel did not frame this error as intentional comment on appellant's failure to testify or post-arrest silence. The fact that appellant stated to Detective Hogan that he was not present at the time of the shooting did not legitimize the prosecutor's trial query to appellant, post-arrest, to tell the jury where he was located at the relevant time. The prosecutor's continued inquiry for appellant to explain where he was located at the time of the shooting is an impermissible comment on appellant's post-arrest silence and right to remain silent. The deficient performance of appellant's trial counsel to object to these comments prejudiced the outcome of the case because this improper argument violated fundamental rights and the evidence of guilt presented at trial was not overwhelming as shown below. The evidence of guilt presented at trial against appellant was not overwhelming. See the entire trial transcript. For instance, 1, neither victim Mitchell nor victim Uten identified appellant as a perpetrator. 2, there was no scientific evidence to connect appellant to these crimes. 3, Ms. Smith was the only person who identified appellant as a perpetrator, and Ms. Smith made multiple inconsistent statements. 4, appellant denied being present at the shooting scene. And 5, there was no video surveillance captured of the shooting. Although the Instagram conversations which were introduced showed appellant interacting with Co-Indictee Ryan and Ms. Hartfield about this event close in time to same occurring, as well as during the police officer's investigation, that evidence should, respectfully, not be deemed sufficient for a finding of no prejudice under Strickland v. Washington. So, based upon the above, appellant's convictions and sentences must be reversed. So there you go. We started talking about shady closing arguments, and there we go. And again, the argument here that Steele is making is the ineffective assistance of counsel for counsel not to object while it was happening, right? So a slightly different argument. He's still spelling out that this was improper for the prosecution to do, but really saying the issue here is the counsel didn't even object. So there we go. We've got one more here. What do you guys think of what we just looked at here? Steele's argument there. And then we'll get to number 3. You know, Andre Cook, I think it would depend on the issue. And the issue here is if it's an ineffective assistance of counsel tacking on to each of these, there could be, right, a parallel argument. If the same issues, and I know that Ryan's appeal involves ineffective assistance of counsel, if they find an ineffective assistance of counsel for something that neither counsel happened to have objected to, I think that just means when the Supreme Court hears Ryan's arguments, they might have to find the same basis there. They agreed to it in another case. Like, what better precedent for the next time if the same argument is made? If they make a finding here that maybe something Blalock's counsel did that was ineffective, but it doesn't really relate to Ryan's counsel for that instance, then there would need to be separate arguments, separate rulings. And I don't think it would just be necessarily sua sponte. I think that they'd have to write out their reasoning. They'd just repeat the same thing. I guess the best answer here is if something like this was granted and Rodalius Ryan's appeal argues the same thing, I would be very confident if I was their appeal team. So, there we go. And baby oil might be... Are we here? Where's P. Diddy's baby oil? I see people talking about baby oil in the chat, so hey to you if you're in here. Oh, man. Yeah, definitely excited here for the oral arguments. And usually it's like they get like 30 minutes each. Well, not really full 30, but it's short, it's concise. It's like, it's just the amount of, and honestly the other side too. Maybe not in this particular case, we'll see what they argue, but I think it's interesting to hear both sides of appeal arguments. It's just like so much. The arguments are concise, they're crunched down to fit these short time blocks. It's not 150 days of trial. They don't get a huge block of time to word salad. So, and Ashley, we have that reading separate somewhere on this channel when it came down. I don't know what date that would have been, but I don't know, about a week and a half ago, we've got the Steele contempt decision on. I think it was a live stream that we did. So. And then, oh, what are we? Kristen Vasquez says peek on Nick. Do you mean on YouTube? What's Nick up to? What is he doing? All right, we're gonna snipe him. What is Nick wearing?
Yeah. And it should have been granted.
Oh my goodness.
He lied to the
Love
court.
it. Love it. Shout out to Nick Starro. Love the costumes. Let me drop a link in case you want to check it out on a bigger screen. It reminds me of... We've got little Rico the duck. Oh, I should have done a costume. Should have done a costume. And there's no guarantee that there will be court today. So, I mean, negotiations can take a long time. They really can. So, seems like that's what's underway. And just because there's negotiations doesn't mean that there will be a deal accepted. So, yep, so there's a response from the DA and also from the Attorney General on this one. So, JH, thank you for the 3. Good to see you. Pop Tot, I love this name. Says, I hope love brings up guilty pleas. I can hear it. I can hear some slick workaround. And I imagine that these attorneys will object to it. But I can hear her excuse why it's acceptable for her to do so. But Pop Tot says, love the name. I hope love brings up guilty pleas. Automatic mistrial with prejudice. No way Paige could say it wouldn't be intentional or like fixable. Right. I would love to see Whitaker try. Like, come on. 1,000% with you here. Thank you for the 5. Oh, man, it's like I can hear the stupid love voice in my head. And then let's get into this third one. Let's get into this third argument. So, appellant's trial counsel rendered ineffective assistance of counsel by failing to realize that evidence existed to disprove the state's theory of the case. Hence, appellant's convictions and sentences must be reversed. So, whether the trial court's finding that appellant's trial counsel did not render ineffective assistance is reviewed under the clearly erroneous standard for factual issues and de novo review for legal issues. So this enumeration of error is preserved for appellate review. The same was raised at the earliest opportunity, the motion for a new trial hearing in 2024. The 6th and 14th Amendments to the United States Constitution and Article 1, Section 1, Paragraph 14 of the Georgia Constitution mandate that trial counsel for the criminally accused must understand the facts and relevant law that pertains to their client's cases. If a trial lawyer is unaware of evidence in her possession that would assist her client's case, same is deficient performance and may prejudice the outcome of the case depending on the facts. So, Woods v. State. In the case at bar, appellant's defense was that 1, he was not present at the scene of the shooting, and 2, the state's theory that no one from inside the victim's vehicle fired their weapons was wrong. At trial, Mr. Mitchell's Instagram records were introduced into evidence by the state. Detective Hogan theorized that no one in the deceased vehicle fired a gun during this incident, and that the ballistic evidence collected supported that only the 2 perpetrators fired guns at the deceased vehicle. Yet, Mr. Mitchell's Instagram records called into question Detective Hogan's theory of this case. Moreover, Ms. Smith was the only witness to testify that appellant, so Blalock, as well as Ryan, both fired bullets into the deceased vehicle. The Instagram conversation from Mr. Mitchell's records would have supported appellant's defense that he was not present at the scene, since there was only one person firing bullets into the deceased vehicle. These Instagram conversations caused the state's theory of the case and Ms. Smith's credibility to be questioned. The trial court correctly found that trial counsel's lack of familiarity with these Instagram conversations was deficient performance. However, the trial court curiously found that the introduction of Mr. Mitchell firing his weapon from inside of his vehicle may have opened the door to Blalock's supposed association with a gang. The trial court cited no case law for this proposition, probably because none should exist. Further, the trial court concluded that because evidence was introduced that Mr. Mitchell possessed a gun during this incident, somehow those Instagram conversations would not have had much impact on the jury. Conversely, these Instagram communications were material to appellant in his defense, as same could explain the ballistic evidence and dispel the state's theory that 2 perpetrators fired at the victim's vehicle, as no bullets were fired from inside their car. Finally, the trial court reasoned that these Instagram messages would have simply impeached Mr. Mitchell. Same is true, but incomplete. Mr. Mitchell, Ms. Smith, and lead homicide detective Hogan's testimonies would all have been challenged based upon these Instagram records. The evidence of guilt presented at trial against appellant was not overwhelming. So, for example, 1, neither victim Mitchell nor victim Uten identified Blalock as a perpetrator. 2, there was no scientific evidence to connect appellant to these crimes. 3, Ms. Smith was the only person who identified Blalock as a perpetrator, and Ms. Smith made multiple inconsistent statements. 4, appellant denied being present at the shooting scene. And 5, there was no video surveillance captured of the shooting. Although the Instagram conversations were introduced and showed appellant interacting with Co-Indictee Ryan and Ms. Hartfield during the time of the shooting, as well as a police officer's investigation, that evidence should respectfully not be deemed sufficient for a finding of prejudice under Strickland v. Washington. Based upon the above, appellant's convictions and sentences must be reversed. And then we're going for the cumulative error. So if you don't find that 1, 2, and 3 are strong enough individually, then we're also raising a cumulative effect of multiple error test. So appellant asserts that if this honorable court concurs with appellant and finds that error was committed as raised in enumeration of errors 1, 2, and or 3, but this court determines that individually these errors are harmless, appellant asks this honorable court to analyze this case under the cumulative error rule. So see Tarver v. State. As argued in enumeration of errors 1, 2, and 3, appellant has raised that 1, the jury instruction coupled with the testimony of a witness who consistently invoked the Fifth Amendment to relevant questions, 2, the prosecutor injecting a burden-shifting / impermissible comment in appellant's post-arrest silence and decision not to testify, and 3, the deficient performance of appellant's trial counsel to read discovery in her possession in order to impeach the state's theory of the case and witnesses for the prosecution should, individually, reverse appellant's convictions and sentences. If this honorable court finds that these asserted errors, when analyzed individually, are not strong enough to reverse appellant's convictions and sentences, but finds that there was error, and that 2 or more of these above referenced issues prejudice the outcome of the case, appellant respectfully requests this honorable court to reverse all convictions and sentences under the cumulative error test. As argued above, the evidence at trial was not overwhelming against appellant. For instance, neither victim Mitchell nor victim Uten identified appellant as perpetrator. There was no scientific evidence to connect appellant to these crimes. Ms. Smith was the only person who identified appellant as a perpetrator, and Ms. Smith made multiple inconsistent statements. And appellant denied being present at the shooting, and there was no video of the shooting. Although the Instagram conversations which were introduced show appellant interacting with Ryan and Ms. Hartfield about this event close in time, to the same time, as well as during the officer's investigation, that evidence should respectfully not be deemed sufficient for a finding of no prejudice. Appellant urges that this honorable court find that there exists reversible error in enumeration of errors number 1, 2, and or 3, individually or alternatively, that there was cumulative error from any combination of these issues, and should reverse all convictions and sentences. So for the foregoing reasons, they basically request a new trial. They want to remand it back down to the Superior Court of Fulton County, reverse these sentences. Brian Steele, there you go.